Join Boise State Public Radio for a concert with blues rock guitarist and vocalist Coco Montoya at the Treefort Music Hall in Boise, February 13th, with reserved seating. A night with Coco Montoya and his band. Find details and a link for tickets at boisestatepublicradio.org.
From the studios of Boise State Public Radio News, I'm Gemma Gaudette. This is Idaho Matters. On Valentine's Day, a case will go back to the Idaho Supreme Court, and the outcome could have major implications for our state's 19 ski resorts. Now, this case began 5 years ago when a skier at the Sun Valley Resort ran into a snowmaking gun and died. Now, at issue is whether the resort was to blame for his death. Idaho has a liability law that helps protect ski resorts, and this case could impact that law and drive insurance costs up for ski hills, and that could put many of the state's smaller operations out of business. Betsy Russell is a retired reporter and a very avid skier, and she recently wrote about this case and its implications for the Idaho Capital Sun. She is joining us live from Bogus Basin Ski Hill right now to talk more about this. Betsy, it's really nice to have you on the show again.
Thanks, Gemma.
So tell us about this Sun Valley case. What happened exactly?
Well, it was the Saturday of Thanksgiving weekend back in 2019 when a skier was going down Lower River Run at Sun Valley, skiing with, quote, poor control, according to court records. The run was groomed. The weather was clear. He skied across the backs of another skier's skis, and then he yelled and fell and crashed headfirst into a tall, yellow padded snowmaking tower gun that was in the middle of the run. Unfortunately, he died of his injuries, and a lawsuit followed that is now threatening to overturn decades of court precedent on ski.
So, Betsy, as you mentioned, a lawsuit was filed. My understanding is that the skier's wife filed this lawsuit against the Sun Valley Resort. So what exactly did it say?
So basically, the lawsuit charged that the accident was the ski resort's fault, not the skiers. That Sun Valley should have done things to prevent this accident from happening. And I saw the decision come through, and it really surprised me from the Idaho Supreme Court. So initially, the district court ruled in favor of Sun Valley and threw out the lawsuit citing our Idaho's ski area liability law. And there's a long line of cases going back for decades about how this is supposed to work. But that was appealed to the Idaho Supreme Court. They overturned it and came out with a very different response. And so now we're looking at a reconsideration of that.
I want to get to that ski area liability law in a minute, but first, my understanding is one of the big issues in this case are those snowmaking guns that the skier ran into. Can you tell us more about these for folks who may not ski, may not get up on these ski hills often? How big are they, and are they marked so skiers can see them?
Sure. So these particular snowmaking tower guns are really tall. I don't know, maybe 10 to 15 feet tall. And they are wrapped in bright yellow padding going up higher than the height of a person. And there's a long line of them right down the middle of this particular run. Sun Valley has had snowmaking since 1974, and they have more than 600 snow guns on their hill. And they're in all different locations. On some runs, they're off to the side. On some runs, they're in the middle. These ones are extremely prominent on this run because they're right down the middle. They're wrapped in bright yellow padding. It's a wide, groomed run. And all around the snowmaking guns are these huge banners saying slow and very slow because skiers are kind of weaving in and out down the run among other skiers, among the snowmaking guns, and so forth, as they make their way down this not very steep run that leads to the bottom of the hill.
So let's talk a little bit more about Idaho's ski area liability law. First off, what is it exactly, and what does it do?
Sure. So this law was first passed in 1979, and it was last amended in 2014. And basically it says that ski resorts have certain enumerated duties that they have to do, and skiers have certain enumerated duties that they need to follow. And if everybody complies with their duties, then a ski resort can't be sued if it's complied with the duties in the law, successfully sued for damages. And a skier can't sue a ski resort for something that was caused by them not complying with their own duties. So the duties that are placed on skiers under the law are things like skiing in control, controlling their speed and course, skiing within their abilities, taking responsibility for inherent risks of skiing, things that a skier might encounter on a ski hill that a ski resort couldn't remove, like trees and towers and bare spots and brush and things like that. And on the other hand, ski resorts have to do these very specific things, including marking hazards, maintaining chairlifts to national safety standards, and a whole lot of other things like that. And one of the specific duties that skiers take on is that they are liable if they collide with plainly visible or properly marked snowmaking equipment. That's right in the law. And so
Beth,
in this case, yeah, go ahead.
No. So go ahead with that, because it was, you said that, I was like, well, that's exactly what happened in this case, it would seem.
Right. And so all of the court cases under this law over the many decades that it's been in effect have upheld the law and held that, as the law says, there's no, quote, standard of care for how well the ski resorts carry out their enumerated duties. And in this case, what the Supreme Court did when they overturned the lower court was they disagreed with that and said there should be a standard of care, and we've now decided it should be something called an ordinarily prudent person standard of care. So the original idea of the law was that if ski resorts did these things, they couldn't be sued for not making it even more safe, for not having done those things well enough. But under this new interpretation from the ski resort, from the state Supreme Court, a jury would have to weigh how well the ski resort complied with each of its requirements. And if the ski resort didn't comply well enough in the view of the jury, then it doesn't matter if the skier complied with their responsibilities. So this would be a problem for the operation of ski resorts. And in particular, the two things that this lawsuit cited were a requirement that ski resorts have to mark snowmaking equipment with a warning implement, although the skiers also are responsible for anything that's plainly visible or marked. And also that they have to post a sign at the top of the run when snowmaking is in progress. So snowmaking wasn't in progress. No snow was coming out of the gun. There were signs at the top of the run because Sun Valley has signs at the top of every one of its chairs and has for 32 years saying snowmaking in progress. But the widow of the skier who died said she didn't see that sign at the top that morning. And she argued in her lawsuit that the law is ambiguous. What does snowmaking is in progress mean? If there's a snow gun out there, but it's not operating, doesn't that still mean snowmaking is in progress because potentially snow could be made? The lower court said, no, the law is not ambiguous. Snowmaking in progress means there's snow coming out onto the road. But the Supreme Court disagreed and said, no, a jury should decide whether snowmaking was in progress because there was a gun that wasn't shooting snow. And and Sun Valley said we had signs there anyway, but the Supreme Court said, well, the widow didn't see them, so this should be considered by a jury. And then on the warning implement, in the lower court, the judge ruled that as a matter of law, the bright yellow padding wrapped around the tower gun is a warning implement. The Supreme Court said, well, maybe it is, maybe it isn't. Let's let a jury decide. That would mean that in every case where someone should sue a ski resort over an accident, it would go to a jury to decide how well ski resorts complied with these duties that were written into the law. And the whole point of the law when it was passed was to limit liability for ski areas, not to increase it. If that were the approach, then it would be a roadmap for how to sue a ski area. Here are things you can try to get them on, if they didn't, sufficiently to the letter of how you're viewing it, comply with this particular duty. Now, the reason this is kind of chilling is because of what happened in 1978 in Vermont that prompted Idaho and a whole lot of other states that have skiing to adopt ski area liability laws in the first place. And that was something I discovered in the course of researching this story. And I have to say, I was pretty stunned. So
Betsy, talk a little bit more about that, because
sure.
Because in what you found in Vermont is that this, I mean, and I don't think this is being over dramatic, decimated a lot of ski areas. So can you talk about what you found out?
Sure. So in 1978 at Stratton Mountain in Vermont, a skier was skiing along a beginner run, and his name was James Sunday. And he got a ski caught in some brush at the edge of the run, and he fell and suffered really serious injuries. He sued the ski resort, and the Vermont Supreme Court found Stratton Mountain 100% responsible for the accident and awarded $1.5 million to the skier. So what the Supreme Court said was skiing doesn't have inherent risks. Essentially, ski resorts have the duty to make skiing safe so that nobody gets hurt. And that's pretty near impossible to do. I'm a skier myself. Basically, if you strap boards on your feet and you head downhill fast, things can happen. There is risk to this sport. And the previous approach to the law in most states recognized that skiing was a sport with inherent risk. So this prompted huge numbers of lawsuits. Liability costs skyrocketed in Vermont, and skiing changed completely in the state of Vermont. In 1970, they had 51 ski resorts. Today, they have 25. All of the small mom and pop resorts, essentially, almost all of them shut down. And now skiing in Vermont consists of these huge commercial resorts run by these big conglomerates, and it's very expensive to ski. And I found this out from talking to people in Vermont, including an attorney who studied this. And they still don't have a good ski area liability law in that state. But this prompted other states to look into what they could do to still have ski resorts and also warn people that there are risks and figure out what is reasonable to expect ski resorts to do to mitigate the risk and what's reasonable to expect skiers to do to take on the risk if they're going to do something risky. And that's kind of the basis of state ski area liability laws. So Idaho's law was actually drafted by Myron Schlechte, who was the chief bill drafter for the Legislative Services Office of the Idaho Legislature, based on model legislation supplied by the National Ski Areas Association and at the request of legislative sponsors. And it has been the law of the land in Idaho ever since. In 2014, the amendments that were added in some things that didn't exist back in 1979, like snowboarding, terrain parks, and also some provisions about inbound avalanches. And that bill passed. And the idea then was skiing is a risky sport. It's not 100% safe, and people can get injured. And so we need to approach it in a way that everyone's aware of that and not just going out and trying to point fingers, because when lawsuits are filed over inherent risks, skiing basically becomes unaffordable. In Idaho, we have 19 ski resorts. Many of them are quite small. Some of them are fairly large. The small ones can't afford huge increases in liability insurance costs. All ski resorts in Idaho are already facing huge increase in property insurance costs because of wildfire risk. And so the fear is what happened in Vermont could happen here. Skiing could change. It could only be at bigger resorts that charge higher prices, and we could lose our local mom and pop ski halls.
And Betsy, if this case stands, I would think that there is concern from these 19 ski areas, these more mom and pop ski areas in Idaho, that they would close down. I mean, you talked with some of these small ski operations, Magic Mountain near Kimberly, Pomerel near Albion. They've got to be watching this and being highly concerned.
Absolutely. All the ski areas in Idaho are really concerned about this case. And I spoke with Gary Miller, who is the owner of Magic Mountain, which is about an hour from Twin Falls. And, it's a family-run operation there. He does the maintenance. He runs the rental shop. He teaches lessons. He loves to do it. He and his wife own it. They've been doing it for 18 years. They would love to continue doing it. They had a lawsuit a few years ago, and it was about a young skier who had run into a tree, and it was very stressful for them. It was expensive. They had to get lawyers and go to court, but they won because of the ski area liability law. And he told me, if we didn't have that law, we'd have to go out of it. We'd be done. And if we didn't have that law, we probably would have lost that lawsuit. And sure, if we did something wrong with a chairlift and a chair fell off and someone was hurt, that's our fault. But if someone runs into a tree, how can we stop that? And that's really the concern. And then I also spoke with Brad Wilson, the general manager of Bogus Basin, which is our nonprofit ski resort here out of Boise. And he's very concerned about this. And he said that the larger resorts like Bogus Basin will survive. They would simply have to raise their prices. And that would make skiing less accessible to everyone. But for the smaller resorts, they don't have any way to do that.
Before I let you go, Betsy, so as I mentioned in the beginning, this case goes back to the Supreme Court on February 14th. Any chance that Idaho lawmakers could step in, that there could be a new liability law at some point? I guess what's next?
So there actually was a bill introduced last year, House Bill 516 in 2024, to simply write a clear statement at the top of the law saying that there is no standard of care for the enumerated duties of ski resorts, which it already says in the law, but it would say it right at the top and make clear that it applies to everything. And that bill did not get a hearing. I spoke with Representative Bruce Skog, who is the chairman of the House Judiciary Committee, and he said it's his preference not to hold a hearing on a bill to change a law until the court process has finished. So he wanted to wait until we see what the Supreme Court does in their reconsideration of their ruling in this case. And that reconsideration argument will be on February 14th, and then it will take some time after that for the decision to come out. But it is certainly possible that we could see a bill come back to clarify the law and to let the court know what the legislature intended with it. When I spoke with former Representative Luke Malik, who sponsored the amendments in 2014, he said the intent of the law is that if the skier violates their duties under the law and causes injury to themselves, they can't collect damages from the resort. And the hope from the ski areas and from former Representative Malik is that the legislature will clarify the law so that it's very clear to the court that it means the same thing it's been interpreted as meaning for the past 40 years by the Idaho Supreme Court and by the federal court.
Well, Betsy, thank you so much for taking time today. As we mentioned, you are up at Bogus Basin skiing today yourself, so we really appreciate you taking time and also really letting us know about this case, but also the ramifications of this. So with that said, we have been speaking with Betsy Russell about a legal case that could have very big ramifications for Idaho's skiing industry. We will, of course, put a link to Betsy's story from the Idaho Capital Sun on our website, boisestatepublicradio.org. And that'll do it for this episode of Idaho Matters. Thanks so much for listening. And just a reminder, you can find all of our episodes wherever you get your podcasts.
Each morning, it's a new opportunity, a chance to start fresh. Up First from NPR makes each morning an opportunity to learn and to understand. Choose to join the world every morning with Up First, a podcast that hands you everything going on across the globe and down the street, all in 15 minutes or less. Start your day informed and anew with Up First by subscribing wherever you get your podcasts.